In Pennsylvania, if you don't have a will, the intestacy laws govern how your assets will be distributed when you die. So, for example, a lot of people think that they don't need a will because they are married and all of their assets are going to go to their spouse anyway. But the truth is that if you don't have a will that says that everything goes to your spouse and you have individual assets, all of your assets will potentially actually not all go to your spouse. So in Pennsylvania, it's important to have a will or a trust so that you are overriding the state rules, the intestacy laws on asset distribution. If you die without a will in Pennsylvania, the intestacy laws determine how your assets will be distributed. So in Pennsylvania, your assets will not all go to your spouse if you have individual assets, unless you have a will that says that your assets all go to your spouse. If you have children or parents that survive you as well, they will also be entitled to a portion of your estate. If you don't have a will in Pennsylvania and money is left to your children will need to have a guardian of their estate appointed in order for assets to be distributed to them. So that's a court process. Even if you have a will, you might still need to have a guardian of the estate appointed if you don't have a trust established in that will. So it's really important in Pennsylvania to establish a trust for your minor children under 18, so that they are able to inherit their assets in the way that you would hope for them to. In Pennsylvania, having a will is probably better than having nothing at all. At least you've stated what your wishes are, but having a poorly drafted will can be just as bad as having no will at all. For example, I have probate clients whose aunt established a will but failed to specifically mention who she wanted to be her residuary beneficiaries. And so the end result was that her residuary beneficiaries were her intestate beneficiaries. The end effect was just like she had no will at all. In Pennsylvania, if you have a will or a revocable living trust, you can amend it at any time while you have capacity. If you are incapacitated, it becomes really difficult to change any provisions in your estate planning documents. So it's really important to always be thinking about updating your estate planning documents when any major changes in your life happen.